Hello everyone, welcome to this session. I'm Nishant, and in this session we will try to cover up Article 20. So we will take a bare reading of this article first. So in the first clause of Article 20, it is mentioned that no person. Now we have already seen that no person includes everyone, citizen or non-citizen, for any offense except for violation of law in force at the time of commission of the act charged as an offense, nor be subjected to penalty greater than which might have been inflicted under the law in force at the time of the commission of the offense. Right? That means no retrospective application of, also that no person shall be prosecuted and punished. Right? Same offense more than once. Now what does prosecution means and what does the punishment means, we will study later. And no person accused of any offense shall be compelled to be a witness against himself. That Article 20 is one of the pillars for fundamental rights guaranteed by the Constitution of India, mainly deals with protection of certain rights in case of conviction for offenses. So the prosecution revolves around a proper trial in the court of law, right? It does not include any administrative inquiries and stuff like that, but a proper trial with evidences in the court of law. Now this article imposes certain constitutional limitation upon the power of the state, right? It is a limitation on the state, and thereby protects a person in respect of conviction of offenses. Now, it safeguards against arbitrary action against the individual, affecting his life and personal liberty. Now, these three subclauses will be discussed. Now, protection against ex post facto law. Right? Article 20, clause 1. It has written cause, but it is clause. Protection against double jeopardy and prohibition against self-incrimination. Now, if we talk about clause A, it is said that not to be convicted, right? But except violation of law in force and at the time of conviction. Right? Now these protections will be available against an ex post facto law. Now what does that mean? पहले हमें ये समझना होगा कि लॉ इन फोर्स का मतलब क्या है. नाउ लॉ इन फोर्स का मतलब ये है कि एक्चुअल एग्जिस्टेंस, राइट, एक्चुअल existence of law at relevant time that excludes retrospective, ठीक है ना, retrospective application. That means कि जब क्राइम हुआ या जब इंसान की कन्विक्शन हो रही है, उससे पहले का लॉ उस पर अप्लाई नहीं होगा. जो कि चल रहा है वो लॉ होगा लॉ इन फोर्स, right? So retrospective application of a particular law is not applicable in case of criminal cases, ठीक है ना. सिविल में है, सिविल में रेट्रोस्पेक्टिव लॉ हो सकता है, जो कि हमने टैक्स केस में देखा था. Retrospective taxation can happen in civil cases but not in criminal cases, right? Now sentencing and conviction is prohibited and not trial itself, ठीक है. Sentencing and conviction, ये दो prohibited है. However, trial for same offense can happen twice, right? only in cases where punishment is greater than those existing at time of commission. ठीक है, अगर पनिशमेंट बढ़ गई है ऐसे किसी क्राइम की जिस क्राइम के लिए पहले सज़ा कम मिलती थी अब ज़्यादा मिलती है, सो उसके लिए दोबारा ट्रायल हो सकता है, राइट। बट उस सेम क्राइम के लिए अगर तो उसे कन्विक्शन पहले हो गई थी तो उसको अब बढ़ाकर दोबारा कन्विक्ट नहीं कर सकते, राइट। एट द ट्रायल स्टेज इट कैन हैपन, however if the conviction is done and the judgment has been given once by the court of law, it cannot be rectified and be made into a greater punishment. Clause B, right. Now clause B says that one should not be punished for same offense. ठीक है ना, one should not be punished for same offense. Now same offense means that it has to be same and identical, ठीक है ना, in term of ingredient and facts as well as parties involved. However, these are a bit more micro elements, though you can write only the ingredients or fact, that would be enough to write the answer, ठीक है ना. And in Om Prakash Gupta case, Gupta versus state of UP, there were few conditions such as that there must be previous proceeding before court of law, for the same offense. Court that did the trial of the case had competent jurisdiction and person over whom the trial happened must be prosecuted by judicial proceedings, right, before a court obviously, and not administrative. These three conditions should be involved if we have to activate this particular clause in an offense for which the person should not be prosecuted for the same offense, right. So these three conditions were given in Om Prakash Gupta versus state of UP, that there should be a previous proceeding, court had competent jurisdiction, and person must be prosecuted for the judicial proceeding before a court of law, right. Now the doctrine of double jeopardy. What does this doctrine mean? That a person must be accused of offense, accused of an offense, prosecution took place before a court of law, right, and person was prosecuted and punished, also offense must be same, right. So these four conditions is that the accused person must be accused for an offense, the prosecution took place before a court of law, prosecuted and punished by the court of law, and offense must be same, right. Now in Maqbool Hussain case, In Maqbool Hussain case, it was said that the accused should not only be prosecuted, not just prosecuted, but also be punished, right? Both the elements must be present, that the prosecution should be done and they should be punished, right? Not just the prosecution itself, but they have to be punished for the same offense for which they were accused. And in service matter on which the question might be asked, that the departmental proceedings, you must have heard about the departmental inquiry and departmental proceedings, which are more of an administrative procedure rather than a court of law. So in these such proceedings are not taken into consideration and are independent of court of law, right? So they will not be called as the court of law, and any punishment which was given by the departmental proceeding or such, it cannot be said that after, if there is a case before court of law, they cannot bring a difference under clause B that this is a double jeopardy, because the first punishment was given by the department and through the departmental and through an administrative procedure and not through a court of law. सो इन दी एंड यही कहा गया है कि डिपार्टमेंटल इंक्वायरी और डिपार्टमेंटल प्रोसीडिंग्स, अगर उसके अंदर कोई डिसीजन होता है, इट विल बी इंडिपेंडेंट ऑफ कोर्ट ऑफ लॉ. This was said in Maqbool Hussain case. So you should remember this case for the clause B. Now, clause C. Now this is protection against self-incrimination, right? ऐसा कोई एविडेंस देना जो आपके अगेंस्ट जाए, या फिर आपको फोर्स करके वो एविडेंस लेना, या फिर किसी भी तरीके से ऐसा एविडेंस देना जो आपके अगेंस्ट जाए उस केस के अंदर, दैट कैन गेट यू कन्विक्टेड, राइट? अगर इसके साथ और भी कुछ लर्न किया जाए तो CRPC का 161 होता है, इसके जो सब क्लॉजेज हैं वो उसमें भी ये मेंशन है, एज वेल एज फ्यू सेक्शंस ऑफ एविडेंस एक्ट का सेक्शन 24, statement to police, right? So any statement given to the police, any evidence that has to be admitted into the court, the section 24 CRPC section 161 and article 20 clause C. The protection against self-incrimination, it means that protection of person accused of an offense, right? So protection of person accused of an offense, ठीक है ना? It is against compulsion, ठीक है ना, to give evidence against yourself, and only against compulsion to give evidence against self, ठीक है ना? Only against self, right? And compulsion, against compulsion to be witness, ठीक है ना? Now what we need to know is that, but where an accused voluntarily gives evidence against self, ठीक है ना? Now this has to be written with section 164 of CRPC. If you can remember, that would be much better, because this section 164 CRPC is in front of the magistrate that is taking a statement, right? And that would not be hit by 161, that a statement has to be given in front of the police officer, because उसकी credibility कम होती है, because वो oath के साथ नहीं लिया जाता. And यही reason है कि section 164 में when the oath is given, it is there in the oath itself that the person who is giving such voluntary statement or the evidence even against themselves, it is not in any through any compulsion, and the person is giving it voluntarily, right? So in that particular case, this article will not be violated, right? Compelling witness, ठीक है ना, compelling witness to give specimen, ठीक है ना, specimen such as handwriting, signatures, ठीक है ना, impression such as print of thumb, ठीक है ना, hand, stuff like that, under court order or investigation officer is not an infringement, ठीक है, it is not an infringement of this particular article, because if there is a court order, then it is taken for the furtherance of the investigation, and अगर IO ले रहा है, IO involved, ठीक है ना, not any other person, IO involved, then it will not be infringement to article 20, because the IO is taking such impressions and signatures for the furtherance of the investigation in criminal cases, right? आर्टिकल के अंदर जो केस है वो है सेल्वी वर्सेस स्टेट ऑफ कर्नाटका, जिसमें ये था कि नार्को एनालिसिस, ब्रेन मैपिंग, पॉलीग्राफ, ठीक है, विदाउट कंसेंट आर अनकॉन्स्टिट्यूशनल, ठीक है। सो आपको ये पता होना चाहिए कि ये डायरेक्टली रिलेटेड है टू राइट टू प्राइवेसी, एंड नार्को एनालिसिस, ब्रेन मैपिंग, पॉलीग्राफ विदाउट द कंसेंट आर अनकॉन्स्टिट्यूशनल, ठीक है। बट इफ दे आस्क यू इन कंटेक्स्ट विद द लेटेस्ट क्रिमिनल प्रोसीजर अमेंडमेंट which you have to read, ठीक है ना, by yourself, and then write your answer. उसके अंदर कुछ चीज़ें अब without the consent can be taken and has to be stored by the central authorities, ठीक है, and वो पावर अब दी जा चुकी है through a specific procedural legislation, right? Now आर्टिकल 20 यहीं ख़त्म होता है, एंड इसके अंदर जो भी क्वेश्चन होगा वो पॉलिटी एंड थ्रू बेयर रीडिंग, जिसका मटेरियल मैं शेयर करता रहूँगा, आप वो कर सकते हो, एंड देन वी विल स्टार्ट आर्टिकल 21 वेन एवर आई विल गेट time, because I have a lot of work pending in the court itself and as for my studies too. So I'll try my best to cover up article 21 in one slide, and then I'll divide the slide in 10-minute videos so that it is easier for you to watch smaller videos than a larger one. So thank you so much and bye bye.